Today, I want to talk about the one topic that has interested me for many years is history of English common law, and I've been reading and studying it a lot. And it is very interesting about English common law is because I'm interested in it is because how it changed because before English common law, or at least the development of the English common law, we had Roman or code law, which is mostly most other countries use code law, which is strictly interpretation of statutory law, like a codes, but not case law, which is interpreting how the judges interpret the law. And that, as we know, in the United States, England, Australia, that law or the common law is the primary legal system in those countries. And it is very interesting, this separation between code law, which is Roman law, and the separation between case law, and how the development in England, especially the case law in very early on between during medieval times. So what interests me is that how this separation happened, what happened, and why didn't England copy or use the Roman law, or what the French law or Roman law that was codified and code law, rather than changing it and becoming ultimately the case law, where the case law, I'll define it, is that the judges interpret the rules, and whatever interpretation they come up with, that becomes the law, and that becomes a case law, which is in American English system and Australian system, you really have to read what the other judges have done so in order to interpret that law. So when the judges make that decision, that law becomes a law. And we have also the system of, which is also English tradition, stare decisis, which the judges, when they're interpreting the law, they have to look what the previous judges have decided, and they have to cite that case that aligns the best with that particular set of facts or circumstances, and the law that would be appropriate to use or to justify why they have decided that case in such a way. So through this series, I will be talking about more history of common law and the birth of common law, English common law, which becomes a case law, as I just said. And I will believe, for most part, for at least first parts of this series, I will be focusing on this book here, which is the birth of English common law, second edition, by R.C. van Koenigkem. I don't know, I'm not sure if I'm pronouncing it correct, but this is the book. If you want to look at it, read it. So my focus will be based on what I've been reading and what I know about medieval law in England. My focus will be especially between 10th and 11th century to 12th century, and this is where the case law, the common law, becomes kind of a new thing, and it separates from a code law in Europe. So for today, I would like to start with Norman and English. So the Norman invasion, or the Norman participation in England, where England before 10th, 11th century, England really did not have a specific system. There was no rules were not written. It was mostly tradition. It was followed by tradition. And one of the early on barristers or lawyers or legal thinkers, Glanville, he decided to write these laws into the system. And it's called the Treatise on the Laws and Customs of the Realm of the England, commonly called Glanville, which is Glanville is the author, and he writes because there's no recorded. This is all based on a tradition. We are talking about medieval time, and there was no rules. And in order to really know, well, there's nothing wrong with the tradition when people know what the tradition is, but then there was also a need to codify that tradition, to write it down. And so that is what happened. But at that time, just to give you a little background, England and medieval Europe really had a feudal system. And we know feudalism becomes this like different lords who own a land through Europe, and they would have like peasants and other people who couldn't afford to buy a land. They would live on that land, but in order to live on that land, kind of lease it, they have to pledge allegiance to that lord that they are sitting, meaning they're going to protect them if they need to go to the army, they're going to go to the military, they need to defend them. In terms, the people, the vassals or people who lived there, they had to they had to understand also that they'll be protected by the Lord. Like, they will have a land, they will have a place to live. But in order to do that, they have to, they have to sign a contract. And it was, I hate to compare it to kind of a maybe slave labor, but not per se slave labor, because these people could leave if they wanted to, but of course, and they could live somewhere else, but they couldn't afford the land. So that is the system. There's no a per se system that would protect the rights. Of course, there's no rights until Magna Carta later on, and even then, and then development of human rights way centuries and centuries later. But meantime, that was the system where the local lords, they owned the land, and they had people who were like vassals, and they were able to stay on that land and confirm it. So one thing, what happened is between, at that time, around 10th, 11th century, there was Normans, when they went to England, they actually moved, and this what's it called amalgamation took place. And I quote from this author: the amalgamation took place at biological level, notably through intermarriages between Norman and English families. And this is very important. This is where you have this kind of I wouldn't say early political alliance between Norman and English families. And this is where the Norman, because it's predominantly French, they start to influence the laws and the regulations in England, because England has this tradition but doesn't have any regulations in the law. So they kind of start working within this feudal system. And then the same thing happens with English language. English, there was no such thing as, I would say, English language, because of course it is influenced by a lot with French, Latin, German, and all that. But there's another quote which is very interesting, that this author claims here, is that English language, which after a massive absorption of French words emerged from the crucible of the Norman occupation as a very different tongue from that of Alfred the Great and Edward the Confessor. So the changes based on a geographical location in England, French kind of merges into the people that lived in England at that time, start to change the language, which becomes officially later on, centuries later on, that English language. And so this is part of kind of the circumstances under which the development of the courts, the feudal courts, and the development of common law, English common law, occurs. So we have lords, we do have a king, and there's a king's bench, where at that time king would travel around with different justices, with him, and they would hear the cases from county to county to county. So they had no central power. And feudal system also was more on a local level, where if you had any dispute, the king would hear it and everything. But really, that wasn't as powerful as when it becomes more centralized. That is where the king takes over the power and enacts the law and promulgates the law and communicates what the laws are going to be in England. But you're still on. And then another thing that I want to add about feudalism is that there was not really a feudal system per se, exactly feudal system as it was in France. So the comparison between French feudal system and English, what English would inherit, is that there was not really, in France, you had a specific set of rules where, the different king would travel and implement that. While in England, it was more, it started to be controlled. So the lords did not have that much power, or landowners. Their power is being kind of restricted, which is a very interesting idea. Another thing that I want to mention, at least for this part, is that the feudalism, which of course enables for this development of common law, is a interesting idea. But it also intermarriages. We also want to talk about intermarriages between Norman and English and English families, and also which that developed into the interesting system, an interesting kind of a contract that where one family influences the other. Another thing that I would like to read a quote from page 8 is that it says, "The marriage of feudalism with non-feudal monarchic system that William the Conqueror inherited from Edward the Confessor. The marriage of Norman feudal leadership with Anglo-Saxon kingship is indeed the most striking example of amalgamation of Anglo-Saxon and Norman strands." So we have these, as people move around and conquest, and French moving towards England, and they move into that system, that becomes influence and a major thing, kind of a, if we can use a modern term, colonial thing, where when French and British and European imperialism spread around the world, and the language and the rules of England and France and Germany and all that. But at that time, there was no really centralized power. That was my case. So in the next part, I will talk about how this centralization occurs once there's this intermarriage between what we call here the Norman feudal leadership and with Anglo-Saxon kingship, that starts to develop into a law, and what eventually where the code law kind of, there's a demarcation point or departure point between code law and what becomes a case law. So that will be the next thing that I will discuss, but this was just a part one.